I call this meeting to order. Welcome to meeting number 30 of the House of Commons Standing Committee on Justice and Human Rights, pursuant to Section 108 Sub 2 and the motion adopted on February 8th, 2022. The committee is meeting on its study of the government and its obligations to the victims of crime. Today's meeting is taking place in hybrid format pursuant to the House Order of June 23rd, 2022. Members attending in person in the room and remotely using the Zoom application. I'd like to take a few moments and a few comments for the benefit of the witnesses and members. Please wait until I recognize by name before speaking. For those, yes?
They're having a hard time hearing you, but do they know about their earpiece?
Oh, okay. So, sorry, that's where I was just getting. There's headsets right there. Unwind them, put them on, change the channel to whatever your preference. So if you're bilingual, you can probably go floor. If it's English, English, French, French. So it's the bottom, the left and right switches to the language of preference, and the top part is the volume. Yeah. Real good. Can you guys hear me now? Just testing. And then there's the volume button on it as well. You can go up or down. Top ones are volume.
That one?
That one?
The lower ones pick whichever channel you want to listen to.
And what about that?
That's open with the red.
Okay.
Hopefully I can.
No?
Okay. And just wave if you can't hear or if there's a translation problem, or you can, just put up your hand and let us know. We'll immediately stop and it won't take your time. So I've already explained the microphone. Interpretation for those on Zoom, I think they're all members, so I think I don't need to repeat that. It's use the icon at the bottom to select floor, English, or French. And reminder that all comments, please, should be addressed to the chair. For members in the room, if you wish to speak, raise your hand. For members on Zoom, please use the raise hand function. And the clerk and I will try to get to you right away. Before I introduce our witnesses, I would like to inform the committee that due to the study on our agenda, some of us may find it difficult to listen to the testimonies presented and or experience discomfort given the nature of the topic being discussed. I'd like to remind our witnesses that agreed so kindly to appear in front of the committee, either in person or via Zoom, and members and staff, that if needed, resources are available. That resources are available to them here at Parliament, and the clerk will certainly contact them, and you're more than welcome to ask for them either during or after if need be. I will allow, if necessary, a little pause for our witnesses in order to deliver their statement in the best environment possible. Our present study would certainly be emotionally challenging for our witnesses, and we admire their courage to come forward and share those very personal situations. I'm sure that all members will agree to that. I have my own little system of, so I don't like interrupting. When there's 30 seconds remaining in your statement, I'll just raise a 30-second card, and then when your time's up, I'll give the time's up card out of time. So yellow and red, just try to wrap it up. I don't want to break your train of thought, but that's how we go, and it's the same application for members as well. So it's 5 minutes for your opening statements, and if you don't get all your information across in the 5 minutes, just I'm sure some of the members will allow you to speak to some of those in their questioning, and feel free to do so in there. So our first witness will be, first three witnesses are Morel Andrews, Diane and Mike Ilisek, and Charlene Bozma. So I will begin with Morel Andrews for 5 minutes.
I would like to thank our host, the Algonquin Anishinaabeg people. I hope that your study incorporates the Truth and Reconciliation Commission's calls to action, notably 36 on culturally relevant services, 41 on addressing the victimization of women and girls, and 57 on training for public servants on the legacy of residential schools, UNDRIP, treaty rights, Indigenous law, and Aboriginal Crown relations. I cannot speak for all victim complainants today or convey the reality of those facing systemic burdens due to their sexual or gender identity, race, class, or disability, but I will do my best to honor their experience as well. Il est impossible d'exprimer.
It is impossible to express the anguish and stress of being a victim complainant of a sexual assault. How can I really explain what it means to see one's case abandoned, to be excluded from procedures, and to have lawyers too busy to speak to you, to know that your attacker will never have a criminal record, or to spend nights crying, trying to interpret the legislation? When I asked other victim complainants what I should say today, these women all said the same thing. They want you to know that the legal system is paternalistic, traumatizing, and that we have the impression of being left out.
Of sexual offenses have the right to request a publication ban under Section 486.4 of the Criminal Code. This ban enforces privacy and eliminates any negative consequences of being publicly identified. Publication bans serve a critical function, and they should remain available to anyone who wants them. But there are considerable issues with respect to how we are informed of our publication bans and how we are given information in order to comply with them and lift them if we so desire. On April 7th, 2021, during the sentencing of my sexual assault case, I learned of the publication ban on my identity. Immediately, I knew that it was not in my interest. While in court, I asked the prosecutor to lift it, but she didn't know how to. Shortly after, I interjected myself and asked the judge to lift it, but she told me she was no longer functus and couldn't help. Later, I was told by Victim Services that I would have to bring my own application to the Superior Court and figure it out on my own. Nobody ever told me about my publication ban. Nobody asked if I wanted it, and nobody explained that if I breached it, I could be fined up to $5,000 and spend 2 years in jail. They said this ban was in my best interest, but I felt trapped. After significant self-advocacy, the Crown agreed to bring an application to the Superior Court, and I was able to ask for my right to speak on May 14th, 2021. This was not a painless task. The offender's attorney opposed my application and tried to delay the hearing by over 2 months. Begging for my right to speak was humiliating, and the court dignifying the offender with an opportunity to argue why I should permanently be silenced was infuriating, dehumanizing, and traumatizing. I told myself to remember what it felt like to be shattered by the legal system, and that one day, for myself and for the others I've met, and for those who would come after us, that I would try to do something about it. L'exigence actuelle.
The current requirement that the judge has to supervise the ability of a victim complainant to speak about his or her own experience is not only paternalistic, but it reinforces a feeling of stigmatization and the idea that victim complainants need to be just protected rather than being represented, informed, and helped.
My recommendations are not complicated. Amend Criminal Code Section 486.4 so that it is no longer an offense for a victim to attribute their own experience. Educate prosecutors and judges on publication bans and our right to choose if we want one. ensure that prosecutors explain the purpose and the scope of a publication ban and seek our consent before asking for one. Simplify the removal process, making it clear that the offender or accused are not a factor. Provide accessible and multilingual information about publication bans, how to comply with them, and how to lift them if we want. And edit the victim impact statement form under Criminal Code Section 722.4 to allow us to opt out of a publication ban at the conclusion of a case without having to justify this decision to the court or the offender. Of every 1,000 sexual assaults in Canada, only 3 will result in a conviction, but publication bans remain on the name of those complainants who have not had a finding of guilt in their case. This is a painful burden for those who want to speak out and gives the impression that our abusers are protected and actually serve to benefit from unwanted bans. Il n'y a aucune justice.
There is no justice in an unwanted publication ban.
And everything expected of me. I reported, I went to court, I have been vocal about this issue, and I have come here today with recommendations. I ask at minimum that you show persistence in championing this much-needed change and that you are audacious in demanding something better for us. Thank you. Merci beaucoup.
Thank you, Ms. Andrews. I would now go to Ms. Buzma for 5 minutes.
Thank you, ladies and gentlemen, for the invitation and the opportunity to speak here today, and thank you to Mr. Brock. I am a victim and have gone through our justice system, I believe the victims' rights and the lack thereof are in a great need of review. My name is Charlene Bosma, and on May 6, 2013, my husband Tim was taken from our home, shot in his own truck across the road from our house, his body eventually taken to Waterloo Airport, and then burned in an animal incinerator. We spent 8 days searching the province for him, not knowing where he was. On the 8th day, my world fell apart, and I learned one of the most horrifying phrases in the English language. His body burned beyond recognition. It took another 3 years before I was allowed to know what that meant. Through the excellent work of the Hamilton Police Department, in conjunction with police forces from surrounding areas, 2 arrests were made shortly thereafter, and in 2016, we spent 6 months at trial in Hamilton. The team of Crown attorneys worked extremely hard and were victorious in not one, but both offenders being convicted of first-degree murder. The investigation into my husband's murder led to further charges being laid for the deaths of Laura Babcock and Wayne Millard, each of which also resulted in first-degree convictions. I cannot convey the overwhelming amount of joy and relief that we as families shared in the courts determining consecutive life sentences in each case. 75 years and 50 years for cold-blooded, heartless killers. As the mother of a little girl who was not quite 2.5 when her father was murdered, I was extremely thankful that she would never, ever have to face the monsters that killed her father for no reason other than they simply could. In comparison to many other homicide families that I've had the unfortunate privilege to have met in the last 9.5 years, our case, our convictions, and our sentencings were the absolute best that anyone in our position could hope for. It allowed hope for other victims that perhaps, yes, in the Canadian justice system, justice might actually be served. And offenders sentenced accordingly to the crimes that they have committed, a true life for a life. Some may say that because of the overall positive experience that I had with the police departments and the Crown Attorney's offices, that I'm in no position commenting on victims' rights. They may be right, but it does not diminish my ability to stand here before you and fight for my daughter's future and for those who were unable to benefit from the same positive experience that I had. Everyone needs and has the rights to the same justice system that was bestowed upon me. In May of this year, our government took away one of the very few things that we as victims had to hold on to, which was consecutive sentencing. It was one of the greatest blows that the Canadian government has ever dealt to victims of violent crime. It says to us that you can kill as many people as you want here in Canada because sentencing will not change. It says that Canada only places values on the first victim, with the lives of any other victims not mattering, not here, not in Canada. My daughter was 2.5 when her father was murdered, as I mentioned earlier. She has no memories of her own of her father. She was never given the chance. It was ripped away from her. All she has are stories and photos that I and others close to him share. And some may say that it's enough, but it's not. She had a right to know her father. She had the right to be raised by him and know him for the loving man that he was, just as much as anyone else. And now, because of the ruling in May, when my daughter is 27, she will be asked to carry on the fight that I thought I already fought for her. The parole hearings will begin. She will be called upon to state why these monsters should not be offered any sense of freedom and why they should stay in prison. She will have to face them. Soulless psychopaths that scarred her life before she even knew that it was her own. In those moments, she will be the little toddler begging for her daddy to come home, but in the body of a woman. She will be defending her father's life and that of Laura's and that of Wayne's to keep those men in jail. It will not only be up to myself, but my daughter to continue the fight because this government puts more value on the life of the criminal than it does its law-abiding citizens. Our nightmare will start all over. We will be re-victimized and relive all the trauma each and every time they apply for parole. As a victim in our current society, we are treated as pariahs in our schools, our places of worship, and our work. In many people's minds, it's easier to believe that we have done something wrong to deserve this rather than to accept that really, truly, there are monsters in human form in this country. If it can happen to us, it can happen to you. As a victim, I can tell you that Canada does not care about us. I ask this committee to prove to me and to all other victims of violent crime that I am wrong. Stand up for us as we have fought to do so for ourselves. Show me that I am wrong.
Thank you, Ms. Bosma. Next to Mr. and Mrs. Alask.
Thank you for allowing us to speak as a witness to the Justice Committee. Our son Brian was brutally murdered while working for an armored car company in 2012. 2 other workers were also murdered, and another co-worker survived, but his life changed immensely after the incident. The victims were betrayed by their co-worker. All were shot in the head at close range. In fact, Brian's funeral was delayed for a week so that his face could be reconstructed to allow a viewing of the body before the celebration of life. The Edmonton Victim Services Unit was a blessing to us as they guided us through the journey of grief. Diane and I also joined the Victims of Homicide Support Society, which had a huge impact. We continue to be involved in this group. It has helped us maintain our strength. The recent decision by the Supreme Court of Canada to strike down the consecutive sentencing law was a very bad decision. This decision impacts all victims and devalues the value of life. When a parole hearing is scheduled, I want to face the offender and not be subjected to look at the back of his head. If the offender is not willing to cooperate, then a hearing shouldn't be allowed to take place.
Our son's murderer was the first offender in Canada to be sentenced under the consecutive sentencing law. He was given a life sentence with no possibility of parole for 40 years. There was a sense of relief knowing that we would not have to attend a parole hearing for 40 years. 40 years would mean that we would never have to go, in all likelihood, to a parole hearing. Now, with the Supreme Court's decision, the murderer has applied to have his 40-year sentence reduced to 25. That means the murderer could be eligible to apply for parole in just 15 years from now. To call this possibility distressing is an understatement. When we discussed this decision with family and friends and our MP, Michael Cooper, we recognized that the majority of people do not support the Supreme Court's decision. The Liberal government should have invoked the notwithstanding clause to override the decision of the Supreme Court. Please listen to the people of Canada. As a victim, I'm mystified and terribly disappointed by the Supreme Court's decision and the government's lack of response. Jail is not cruel and unjust, but murder is. Recommendation number 1, the government should have invoked the notwithstanding clause and override the Bissonnette decision. I'm disappointed that there has been no response from Justice David Lametti other than he says he respects the decision by the Supreme Court. Recommendation number 2, please don't allow mass murderers like our son's murderer a chance to get their parole after 25 years. Recommendation number 3, parliamentarians should visit penitentiaries and learn. Jail's not a cruel place to reside. Inmates enjoy many benefits that taxpayers pay for. All their meals are free. There's no free fee for room and board. Inmates are offered education. They could possibly end up with a bachelor's degree or a master's degree. But what about the victims left behind? Recommendation number 4. When this incident occurred, I happened to be in a deep amount of sorrow and grief. I recognized that I needed counseling. Could counseling sessions be paid for by the government? In 2012, the fee for counseling was $185 an hour. Who could afford that? Recommendation number 5. Please sponsor a way for victims to navigate the justice system. A victim's advocate should be established to help victims navigate the system and arm them with all the information they need and deserve. In closing, we want to let you know we have registered with the Victim Notification through Corrections Canada Corrections, but we are not receiving updated notifications as promised. The updates would be greatly appreciated. Thank you for your time and consideration. And I just want to say we've been through the journey and we're still going through it too.
Thank you to all the witnesses. It's not easy sharing your stories, and I'm sure you've had to share them over and over again. So I urge all the our panelists, our members, to also keep the sensitivities in mind when asking questions. So I'll begin with Mr. Brock for 6 minutes.
Thank you, Mr. Chair. I'd like to start by thanking all of the participants today for your courage to come forward and share an extremely difficult chapter in your lives. You are all to be commended for having that strength to come forward and to advocate not only on your behalf, your family's behalf, but on all the victims that exist in Canada. So thank you so much. To you, Ms. Andrews, I listened very carefully to your words. We've had an opportunity of speaking prior to your attendance today. I want to assure you that your voice has been heard very loudly at this commission, that your voice will be heard nationally and shared with the Government of Canada. And I also look at some of the material that we talked about in preparation, and I just want to comment briefly on the decision that the judge made in the case that you were a victim of just over a year ago. And her closing statement to the offender was directed to you. I'm sure going forward, your voice will have great impact. And really, what a foreshadowing of where you are today. So I really want to thank you for the resiliency and the strength that you are showing to advocate in an area that is in so desperate need of reform. So I want to specifically ask you a couple of questions. I've got basically a minute. You talk about a lack of trust. You talk about a lack of communication. You talk a lack of participation in the process. All of these issues are enshrined in the current version of the Victim Bill of Rights, but clearly you did not have that experience. So can you be more specific as to how we can ensure that victims such as yourself, other victims that come before the courts, victims from marginalized communities, victims where English is not their first language, how they can receive just treatment by all justice participants?
Mr. Chair, there's three parts of the Victims' Bill of Rights: information, protection, and participation. That particularly I look at as a victim. And I felt throughout the process, as I navigated the legal system, that those did not apply to me. I was not protected, either due to malice or negligence on the Crown's behalf, of placing a publication ban on my identity without any knowledge. I could have lost my job. I'm a public servant. I have to maintain a security clearance. If I'm charged with a crime, my job is gone. Information, it was like pulling teeth to try to understand how to navigate the legal process. I tried to go to legal aid. I tried to access sexual assault centers. Nobody could help me. I really felt that I was alone. I had to scour Canley by myself to try to find case law. There was simply no one to lean on, and my Crown didn't really have the time of day to speak with me. I understand resourcing issues, but as a victim at a time of need, there's really no support. As for participation, I felt that I had a right to be asked whether I wanted a publication ban. That seems like a very foundational element of participation that nobody ever involved me in. I didn't even know that I could be involved. And that's the case for many victims that I have been connected with, whose stories I hope to share today. But quite frankly, the entire Victims' Bill of Rights is 2,011 words, and my victim impact statement, which has a number of critiques and comments on our system, is 2,300 words. So it can definitely be expanded on.
Thank you, Ms. Andrews. To Ms. Bosma, my sincerest condolences for your horrific and tragic loss. Words cannot describe what you and your family have gone through, and my heart goes out to you. I have a very limited amount of time, about a minute and 30 seconds. I want to focus in on an aspect that you did not indicate in your opening statement, but I know that you experienced, and that is the participation of your right to file and to speak directly to the court on a victim impact statement. Can you expand upon that? And can you tell me how you were treated? Was it fair? Were you allowed to use all of your words without any editing, without any sanitization, without any challenges by defense and or the accused? Can you share that, please?
Sure. In our particular case, because we had first-degree convictions and it's an automatic 25-year sentence before parole, the Crown Attorney actually recommended that we do not file victim impact statements because we were able to go immediately to sentencing. Otherwise, it would have delayed the process. We had been given the forms that we were to submit to the courts so they could be reviewed. I think it was by at three different levels. And the accused were going to have an opportunity to review our statements as well and make any recommendations or corrections that they so chose before we would be able to read them in court. In our particular situation, no, we bypassed the entire thing. So the day that we got the conviction, we sent them to prison.
Okay. And I think I'm out of time, Mr. Chair.
Yes.
Thank you.
To Ms. Diab for 6 minutes.
Thank you very much, Mr. Chair, and to all of you here today. I, too, want to commend you for appearing before us, for your bravery and for sharing your for advocating and through your pain and sorrow that you have experienced. Whatever we say here won't do justice. This is a Justice and a Human Rights Committee, but won't do justice to the pain you've experienced and to the pain that you continue to experience and to the fact that you have lost your loved ones, Mr. and Mrs. Lezik, your son, and Charlene, your husband, and your daughter, her father. I want to ask Ms. Morell, and thank you for the conversation we had earlier today regarding publication bans. I want to put it on record. I think I had asked you on the phone if you recognized the name of Rehtaeh Parsons, and you said you did. So in my own province of Nova Scotia, Rehtaeh Parsons was a 17-year-old victim of child pornography who in 2012 was victimized by 4 boys, and her pictures were taken of her and they were circulated online. Rehtaeh ended up taking her own life as a 17-year-old high school girl who lived in Dartmouth, was was known in her school and in her community. When I entered public life as a provincial member of Nova Scotia, I, was handed the task of being Minister of Justice and Attorney General, and it came on my desk in 2014. A publication ban had been placed on her name. Under Section 486.4 in brackets 3, the Criminal Code, the ban was in place despite the wishes of her mom, her dad, and all the supporters. I remember just before Christmas 2014, and I had taken weeks. It was a very challenging time, but I issued a ministerial directive to the Public Prosecution Service, one I was told at the time had never been done before. That said that no breach of the publication ban on Rehtaeh's name in any form would be prosecuted. But I added the following, which was probably me as a mother, as a woman, as a person who wasn't really in politics before, and I said, unless her name was used in a derogatory way. So at the time that was difficult to do because the prosecution hadn't seen it. Courts were, needless to say, the Justice Department, everyone else, but it was the right thing to do. So I'm sympathetic to what you're advocating for. What you told me on the phone, though, is, and what you shared with me, through your activism, you have encountered many other women with stories. And I promised to give you the chance for the couple of minutes I have left for you to tell us their stories and put them on record for the benefit of this committee.
Thank you. In January 2020, Matthew McKnight was found guilty of 5 counts of sexual assault. His 13 victims in Edmonton have not lifted their publication bans, but I want to tell you about NT. She said that sharing her story is an incredibly important part of healing, and she fought for changes to reverse the UCP's Bill 16 and helps other survivors today. She never consented to having a publication ban. In Toronto, Marika Freund applied to have her publication ban removed. She learned of it 2 years after her trial. She had to ask for the help of 2 lawyers to help her lift her publication ban. The ban on her name was not lifted until October 2021 because the former accused was granted an extra 70 days to come up with a valid argument about why the ban should remain in place. She never consented to having a publication ban. In Victoria, Kelly Favreau, who's in the room today, represented herself in court to have her publication ban removed. She learned of her publication ban 4 years after court proceedings concluded. She says the process took away her autonomy for a second time and feels re-victimized by the justice system. She never consented to having a publication ban. In Dartmouth, Carrie Lowe had to retain her own lawyer to lift her publication ban that she didn't want. She says, someone took away my right to have my own name out there without telling me, then I had to try to go through another court process to have it removed. It's very unfair and it's very unjust. The judge noted that he would not have revoked the ban without the consent of the Crown. She never consented to having a publication ban. In Barrie, Brandy, who's in the room today, lifted the publication ban in her name in May 2022 after reporting a historic sexual assault that happened 30 years ago. She says the Canadian legal system has taken part of my voice, and I'm truly disappointed in the system's inability to support survivors. She never consented to having a publication ban. S in Toronto, who has a publication ban on her name still, says that the accuracy and transparency of information provided to her in the legal system was a problem. She said that the victim services worker told her she needed money and a lawyer to lift her publication ban, and this is not true. She says that the publication ban silenced and protected her abuser. She never consented to having a publication ban. In August 2022, a victim in Nanaimo named Jade had her publication ban lifted. Her publication ban was initially denied. The application to lift her publication ban was initially denied, and she was told that she should have asked for it to be lifted before the matter was complete. She asked to have her publication ban lifted 3 times before it was finally granted, and the matter was resolved. She never consented to having a publication ban.
Thank you, Ms. Andrews.
Thank you.
Thank you, Ms. Diab. Next to Monsieur Fortin for 6 minutes.
Thank you, Mr. Chairman. I want to thank the 4 witnesses who are here with us this afternoon. Your evidence is important, and as my colleagues around the table have said, my sympathies go out to you. What you have experienced are very difficult events. I will just speak in English. This is the interpreter. We'll just check the interpretation and make sure that all of the witnesses can hear the English channel. This is the English channel, the interpretation on the English channel. We're checking to see if the English is coming through on the interpretation channel for the witnesses. Thank you, Mr. Chairman. As I was saying, I express my sympathy for the pain that you have experienced, and as of other colleagues have expressed, we have a great deal of compassion for you. We are trying to resolve the various problems as far as we can, and there are a few points I want us to go over. I find very interesting the point raised by Ms. Andrews about publication bans. So from what I understand, you would have preferred that there was no ban that was imposed without your request. But I would like to know, why did you not want a publication ban? And did you have any consultation with a Crown attorney or a judge to indicate how a publication ban could be useful to you?
With Crown or any lawyers, I received literally none. The only reason I knew that there was a publication ban on my name was because the judge mentioned it in passing during the sentencing hearing. And I, as the victim, was on the call completely shocked because no one had ever told me about a publication ban. And I knew immediately I didn't want it. But nobody seemed to know how to lift it or, wanted to help me at all. There are so many reasons why I wanted to lift the publication ban, and the biggest one is to just simply be free. I knew that I had wanted to publish my victim impact statement at the conclusion of my case simply on my Instagram and my Twitter. I didn't plan on ever being in this position. But when I found out that I was barred from speaking, I knew that there was something that I had to do to make sure that this didn't happen again. And the women who I speak with who talk about why they want their publication bans lifted, it's anything to, advocate for others who have been in the same situation, to, creating art that they feel is important for their healing. For me, I wanted the words to be out into the world and have people do with that what they would. But for some people, it's really important to speak out. For others, publication bans are helpful tools, and they feel protected by that. And that's also extremely important to recognize. But some of us don't want them.
Est-ce que vous avez eu des discussions?
Did you have any discussions with the Crown Attorney when you wanted to have the publication ban lifted? What were you told?
The Crown to lift it. So in my case, we had a lunch break, and the judge in the first half had mentioned the publication ban. When I heard this, I sent an email to my victim services worker, and I said, "Tell the Crown to lift this. I don't want it." And they went back and forth, and the Crown's answer was, "I don't know how to lift it, and I don't know what our policy is for lifting it," which felt absurd to me because I, at the time, was a 26-year-old adult woman, and this ban was meant to protect my own identity. Who else should weigh in on that question than me? I should determine what is helpful for my protection and what I want in my own case. There are different types of publication bans that can apply to cases, none of which that I was subject to. This one was meant to protect my own interests, and the Crown felt it was not necessary to proceed and ask it to be lifted that day in court.
Et est-ce que vous avez soulevé?
Did you raise the point before the judge during the proceedings that the Crown did not know how to have the ban lifted?
At that point, I had already delivered my victim impact statement, and as a victim, you are a witness to a crime. You don't actually have the right to participate in proceedings. So I couldn't actually say anything. But me being myself, I put myself off of mute, and I said to the judge, "Can we talk about this publication ban?" And she simply said, "Well, I'm no longer functus. I don't have jurisdiction on the case." So I wasn't even given the space to explain that I had asked the Crown to lift the ban and that the Crown had declined, and the judge could have done it. The judge just said, "I can't do this. You have to go to a superior court to do so." But I will add that a recent case in 2021, CBC versus Manitoba, at the Supreme Court of Canada clarified that courts of appeal do have the ability to lift publication bans that were initially heard in their level of court. They don't have to go to a higher level of court. So at least that has been clarified. But my understanding is that Crown attorneys and judges have a limited understanding of how publication bans can be lifted and the functions for victims who don't want them.
J'aimerais voir.
I would like to see something. The cooperation that you didn't have or did have with the Crown, if we just leave aside the publication ban, what about the various steps in the process? Did you have good consultation and information from the Crown? Did you understand the process as it went along?
To speak to the Crown attorney in my case, once they had decided that they would be doing a joint submission with the defense, my sexual assault case ended up being a plea deal for the lesser charge of assault. And when the Crown had come to the determination that that was what they would be submitting to the court, they did have a call with me and kind of informed me and asked what I thought. But there's very little explanation by the Crown. There's so many terms that are thrown out in the process. What is a bench warrant? What are submissions? What do all of these things mean? And there's no one who really explains it to you. So I only had a very brief interaction with the Crown, and actually the initial prosecutor who had my file didn't even show up to court that day. It was a different Crown who I'd never met in my life. I didn't even know that she was the Crown until she started speaking. So in terms of meaningful collaboration or consultation, I wouldn't say that it was either of those two words.
Thank you, Monsieur Fortin. Next, we'll go over to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair. And I do, too, want to start by thanking all four witnesses for being here today. I can't imagine, as I have said before, the trauma and grief that is revisited upon victims in our legal system. But I congratulate all four of you on trying to take this horrible experience you've gone through and turn it into something positive in the legal system. And in particular, what I hear consistently from victims and what I believe I've heard from you today is that a big motivation is making sure this doesn't happen to anyone else in the future. And so I thank you for that. I want to focus my questions with Ms. Andrews today because the question of publication bans is an aspect we haven't actually dealt with before in this committee. And Ms. Andrews, you made reference to very specific recommendations, and I know you've submitted a written brief which will eventually be translated and circulated, but I'd like to give you a chance just to walk through those very specific recommendations again.
Thank you. Mr. Chair, I'll give you the long form of my recommendations. Those were the short ones in my opening remarks. What I'm hoping to see is an ability that allows victim complainants with the chance to publish, broadcast, and transmit self-identifying information at any point in proceedings without seeking the approval of the court, so long as the publication is not likely to identify another victim complainant who does not provide consent to be identified. I think we should facilitate adult victim complainants with the ability to provide one-time or ongoing consent through a simplified and publicly accessible ex parte memo or application to the court for a third party, such as a family member or media, to publish, broadcast, and transmit identifying information at any point in proceedings, subject to specific limits that are determined by the victim herself, the victim complainant, I should say, herself, without consideration for the views or notification of the offender or accused, so long as publication is not likely to lead to another victim who has not consented to being publicly identified. And I think that we should facilitate the total removal of publication bans at any point during or after proceedings at the request of an adult victim, or in the case of a deceased victim, the request can be made by a spouse, parent, guardian, or adult child through a simplified and publicly accessible ex parte memo or application to the court without consideration or notification of the offender or accused. This has actually already been done in other jurisdictions. In 2020, Australia changed their law that provided these remedies for victims in recognition that the current system they had at the time was extremely paternalistic and removed agency from victims themselves. I think what would have helped me is an ability to go onto the Department of Justice's website and really understand the scope of my publication ban, what it covered, how to comply with it, and how to have it lifted. You don't have to retain a lawyer to lift a publication ban today, but I still don't know how to do that. I asked a million times and nobody helped me. Kelly did it herself, which I think is incredible and amazing, but it is possible, but there's no information out there. I would also say that, a small tweak to the victim impact statement form would facilitate the removal of a publication ban during proceedings when a judge on the case could still actually do so. There's a small box at the bottom of the victim impact statement that says, yes, I want to deliver this in court. Just add a little box at the bottom, it's a Word document, that says, yes, I would like the publication ban under section 486.4 to be removed. Simple as that.
And I think you've also been very clear, but I do want to give you a chance to restate this, that you believe that for some victims, a publication ban can be useful, but the presumption from the court seems to be that a publication ban is appropriate for all victims.
Absolutely. Publication bans are really, really important tools, and under no circumstance should people not have access to them. And I respect any victim of a sexual offense who chooses to keep her publication ban in place. But for those people who don't want them, we need to make sure that our processes and procedures do not re-victimize victims and complainants, because that's what's currently happening. And especially in the case, I think, of women disproportionately women who come through a court case and have no finding of guilt. They're not labeled a victim, they're labeled a complainant, but they still have publication bans that are permanent until a judge lifts it. So that needs to be addressed as well, because it's not just about those who have had a finding of guilt. It's about anyone who has come forward and has had a Crown prosecutor put a ban on their name.
And again, would you say that in most cases it seems to be a presumption that a publication ban is the appropriate thing with sexual offenses, that it's almost presumed that one would always be in place?
Yeah, it is definitely, I think it's definitely assumed by Crowns that everyone will want one. And so they put them on without asking. I would have never wanted one. And many of the women I speak to also wouldn't have wanted one. It should be about consent. That's a foundational element of feminism, and I'm a feminist, and it should be about choice.
Great. Thanks very much. Mr. Chair, I can't, of course, see you at this point, so I'm not sure how much time I have left.
Sure, you have about 8 seconds, but thank you.
Thanks very much.
Next, we'll go to Mr. Cooper for 5 minutes.
Thank you very much, Mr. Chair, and I want to first of all thank all of the witnesses. My heart goes out to you. It is difficult and it is courageous for you to be here to share what you've gone through as victims. And, you know, Mike and Diane, I've had the privilege of knowing you for about 6 years. And you spoke in your testimony, your frustration with the failure of the government, the Liberal government, to respond to the Bissonnette decision by way of invoking the notwithstanding clause or doing anything else. Indeed, as you noted, the Justice Minister said simply that he respected the decision. Mike and Diane and Madame Bosma, could you tell the committee what message do you think that sends to you as a victim that the minister respects the decision and chooses to do nothing more?
In our case, I feel like it says when you have more than one victim, only the first one that goes to trial counts. Everyone else, even though you go through the entire process to find guilt or innocence, as however it may be, you go through the trial, you get the conviction, but nothing actually changes. They don't serve. They aren't. I'm trying to find the right terminology. There's no punishment for, you can kill as many people as you want here. You're only going to serve one sentence.
Mike and Diane?
In our case,
No, you go ahead, Diane. Yeah.
we had originally started with 3 convictions of first-degree murder. And unfortunately, through the plea bargaining, what happened in plea bargaining is the perpetrator got the sentence reduced to a minimum type of sentence for murder. And we were told by the Crown prosecutors at that time, we just honor that because murder is murder and we're going to go on that premises. But that's why he got 40 years and not anything more than 40 years. Personally, we would like to have seen more than 40 years, but again, the plea bargaining process and the agreement between the perpetrator and the justice system allowed him to plea bargain down more time.
If I may, when we heard about the decision, our kids, we have 3 other sons. Traditionally, we treat Brian's death, how would you put it? Traditionally, we recognize the fact that even though Brian is dead, we still honor him for his birthday, for any other celebrations that we have. And we do that. We don't really discuss what happened. When we shared with our sons that, yes, we might have to be going to court. We don't know if we're going to live that long, but we'd ask them to sign up for the victim notification, to pick up the fight on our behalf. They're not kind of willing to do that because they don't have any faith in the way the current justice system is going. So along with that, like I say, Diane and I are getting on in the years. Hopefully in 15 years, if this does happen, like I said earlier, I still want to face him regardless of how it goes. And I'm adamant that if he thinks that he's not going to meet me face to face, we will be having further discussions.
Thank you. And I just have a short time, so I'll ask both Mike and Diane and Madame Bosma, one of the things the government could be doing, and not just in the face of this decision, but more broadly, is amending the Corrections and Conditional Release Act so that in instances of persons convicted of first or second degree murder, that after they apply in 25 years, in the case of first degree murder, and they're turned down, as is almost always going to be the case, that in 18 months or 2 years, they're not applying again, that they have to wait longer, perhaps 5 years or 7 years. Is that a measure that you think the government should undertake? Would that be a benefit to you?
If I may, I feel that that's at least a step in the direction, to help along with, to assist the families, basically, I guess, I still don't think our family is probably going to buy into it because they really don't have any faith in it. When all this took place, we did start a petition to get the government to invoke a notwithstanding clause. We even had difficulty having our children sign this. Once the petition picked up some steam, they signed it. They farmed out to all their friends and family. And we have a tremendous amount of names on this petition that we're trying to work.
Very quickly, Ms. Bosma.
Okay. I don't feel it's enough, especially when you have multiple convictions. It's 18 months, 2 years. That's not enough. When you're talking 3, 4, however many victims, however many charges, there needs to be something that acknowledges every other family that has suffered at the hands of those people. In our case, we just happened to be the first one that went to trial. But Tim was the third one. He was the last one that was killed, but we just went first to trial. So we got the first conviction, and that 25 years stands for him. As far as it's not enough. It's an itty-bitty baby step towards the right direction, but that will never be enough.
Thank you, Ms. Bosma. Thank you, Mr. Cooper. Now we'll go to Ms. Dillon for 5 minutes.
Mr. Chair, I am so very, very sorry, and the committee, I think, feels your sorrow as you speak. It's in your eyes. You're going to live with this grief for the rest of your lives, and you've conveyed that to us, and our heartfelt sympathies are with you. I'd like to start with Ms. Andrews, please. You spoke about how difficult it was navigating the justice system when it came to victims' rights. What concrete steps can we take, can our government take, to make sure that victim rights are better explained to those who are pressing charges, who are going through the court system, who are trying to navigate their way through? What can be done to concretely help them through this process? Thank you.
I think a big piece is information. Everyone approaches navigating the legal system a little differently. I'm very type A, so I wanted to have every single piece of information I could possibly have. The problem was that it's all very piecemeal, and trying to understand the complexities of what a conditional discharge was versus like a conviction versus, you know, all the terminology that comes at you, it's really challenging. So I think starting off with language as a basis could be really helpful. I don't know if that's like a glossary of terms that could be provided to victims or victim service workers. But even just like understanding the language of the legal system is really hard. And English is my first language. I reported in Ontario. If I was a francophone in Ontario, I don't know that I would have had the same access. If I was an immigrant to Canada and English was my third or fourth language, I truly do not know how it would be possible. I had a good experience compared to most people, and even that experience I thought would destroy me. But I'm here today. And, you know, the publication ban, the amendments that could be made to the use of publication bans, it's just one marginal change. It's one piece that I think that I can be helpful on, but there are so many other issues. Paying for court transcripts, it costs me $500 to get my transcript. Paying for therapy, nearly $6,000 and counting. Crown attorneys were too busy to speak with me after the conclusion of my case. They'll speak to you before, but after there's a guilty plea and a sentence, they have other things to do. Advocates who actually know the correct information are critical. My victim services person told me that my publication ban was automatic, and it was something that happens to every single case, and that's not true. Filing freedom of information requests with the police resulted in nothing. Everything was redacted. There are few resources that are easy to navigate. I, for example, didn't know that there was such thing as sexual assault and domestic violence leave in Ontario. I found out on Twitter that I could actually take that and show up to court. If you are someone who does not have benefits through your employment, if you are someone who faces systemic burdens, if you are someone who feels that the police won't take you seriously, these are systemic issues. Victims are not adequately supported.
And in your opinion, who should be tasked with informing the victims on publication bans, on these types of, I would say, not benefits, but aid, such as leave from work?
Very quickly.
The criminal code right now says that the presiding judge or justice shall at first reasonable opportunity inform any victim of the right to make an application for the order. In practice, this doesn't happen. A victim doesn't see a judge until way down the line, and publication bans are normally put in place at the first appearance of the accused in court. So it needs to either be the Crown attorneys who are doing it or the victim services workers who are doing it. I am not a member of the system or a legal practitioner, so I don't know the intricacies, but someone has to take responsibility because right now nobody is. And we are harming people and we are putting people at risk. A victim in Kitchener-Waterloo was prosecuted last year for breaching her own publication ban. So someone's got to tell us. I don't know exactly who, but somebody needs to.
Thank you very much.
Thank you, Ms. Dillon. Thank you to all the witnesses. I really, from the bottom of our hearts, from all of our committee members, thank you for sharing your stories, and for others that are in the witness gallery that might have had similar stories or even hearing this. Again, I just want to remind you, if you need any services, please contact the clerk, who you all should have information and get those. Next, we're just going to now suspend while the next round of witnesses comes in, but thank you once again for your testimony. I'll just suspend for a minute while we do audio checks and get our next witness ready. our new witness, that hopefully your headset is okay and you've adjusted it to the right channel. Just also to Mr. Garrison, if he's listening, I think, yeah, your boom on your mic looks perfect now. The interpreters had said if you could lower it, yeah, I think you're at the right level right now, so we should be good. Again, I will just repeat for our witness, he wasn't here earlier, due to the sensitive nature of our discussion today, that you may find, if anybody here finds it difficult to listen or the testimonies presented or experience discomfort or any nature of the topic being discussed, I'd like to remind witness that they, either on Zoom or otherwise, that they have the ability to use House resources, and if you feel the need, please contact the clerk. And also, if necessary, take a pause. Don't feel rushed, even though the witness time is 5 minutes, but if you're needing a little extra time, please don't hesitate. So we have now before us Dr. Hamid Ismailian, if I said it right, President and spokesperson of the Association of the Families of Victims of Flight PS 752. So over to you for 5 minutes.
Good afternoon, Mr. Chair. Thank you to you and the esteemed members of the committee for having me here this afternoon to testify on the government's obligation to the victims of crime. More than 1,000 days have passed since the day we saw missile attacks against a civilian airliner over the skies of Tehran. 176 human beings and an unborn child were murdered. Brides and grooms were murdered. Children were murdered. Many of the passengers were students with promising futures for Canada, for Iran. They all lost their lives senselessly just over 1,000 days ago, a milestone that we commemorated here on Parliament Hill just 2 days ago with a march and rally. Where do we stand? Where does the world stand? Where is justice in all of the politics, legal wrangling, negotiations, and bureaucracy? The families of the victims were caught up in the aftermath of an atrocity that is unprecedented in the history of aviation. Despite their grief and anguish, the majority of the families have stood together along this unbearably difficult path. They have tried everything within their means to unveil the truth. The real stakeholders in this heinous crime have no power to decide, have no rights to information, and have no place at the negotiation table, not even their legal representatives. Within 5 hours after the shooting down of Flight PS 752, when bulldozers grazed the site and destroyed evidence, the gears of justice must have engaged. From the moment that it was clear that the IRGC fired the missiles that brought down Flight PS 752, the absurdity of leaving the investigation to the perpetrators must have been addressed. From the moment witnesses and victims' families were harassed, intimidated, and persecuted, an impartial international investigative body must have engaged with the whole affair. 55 Canadian citizens were murdered. Another 83 victims had close ties to Canada, but despite our efforts, the RCMP to date refuses to open a domestic criminal case because the perpetrators of this crime will not cooperate with them. It is my understanding from numerous conversations with people in the Canadian legal community, including a former Minister of Justice, that they have the power to do so, and it is my hope that this committee can aid in pushing that forward. The ICAO has yet to condemn the Islamic Republic's breaches of its conventions with an absurd claim of neutrality. We are pushing for them to do so when this new session opens to finally right this gross oversight. We don't want to hear about the complexity and delicacy of the matter. We are the biggest stakeholders, and by now, more than 1,000 days later, we know all too well that the road to justice for us is not easy, short, or simple one. We demand a clear roadmap with concrete action. We demand empathy backed up by real turns in the gears of justice. We are not lawyers or diplomats or politicians. We are a collective of grieving families who deserve reparations that include the truth, justice, and closure, not empty apologies or financial compensation. Here is what must be done. 1, our case must be tabled at the ICAO Council without delay and with urgency, and we must prepare our case to the International Court of Justice. 2, Canada must support our submission in International Criminal Court through a state referral or a support letter. 3, the RCMP must open a domestic criminal case in Canada. 4, the IRGC must be on the terrorist list without delay. I call on parliamentarians of all parties and stripes to help us push forward in making these demands a reality. While I'm here, let me also just thank and commend all parties for working together with us on this to date. We have been grateful for your time and attention on this matter and your show of support both here at the rally, anniversaries past and future. We shall continue our efforts with increasing resolve, and even after 1,000 days, our pain, our shattered lives, our success, or even failure to get results, to unveil the truth and get justice, can only pave the way for freedom and justice in Iran. No matter how long it takes, we stand firm for justice and human rights. We shall never forget, nor shall we ever forgive. Thank you once again, and I welcome your questions on your work and mandate. Thank you.
Thank you. Thank you for that. Now to Mr. Cooper for 6 minutes.
Thank you, Mr. Chair. Dr. Millian, good to see you again. When you appeared before the Subcommittee on International Human Rights in June, I had asked you about failure of the government to designate the IRGC as a terrorist entity. It's now 4 months later, and still no action, as you said, more than 1,000 days after PS 752 was shot down, murdering 85 Canadian citizens and permanent residents, a total of 176 passengers, and still no action. So can you speak to that, your frustration with the inaction? You met at the time with the Minister of Foreign Affairs. Obviously nothing progressed from that meeting. And from a victim's standpoint, can you speak to the fact that in designating the IRGC as a terrorist entity, it's not merely a symbolic gesture. From a victim's standpoint, it provides real teeth for victims to get justice, including allowing for the Justice for Victims of Terrorism Act to be utilized.
We always said to the government that, when we hear that this legal case, it takes a long time, then we said, okay, if you want to wait, let us some good signals, positive signals that you're serious about the case. And putting IRGC on the list is one of the signals. This is a puzzle for us, that why IRGC is not on the list. We know that Quds Force is on the list already, but this is an external branch of IRGC, and we all know that who shot down the plane. The internal branch of IRGC did it. This is an entity that murdered Zahra Kazemi, murdered Qais Emami, and right now in the streets of Iran, this is the entity that shoots at innocent people. So if we are serious about justice and about this case, as we believe we have to show some teeth to Iran, and putting IRGC on the list is one of the basic steps that our government can take.
Well, thank you for that. And in your testimony back in June, you also noted that your organization, on behalf of the victims, has provided or attempted to provide the government with a list of 50 individuals who are known to be involved in the shooting down of PS 752. And as of June, no action has been taken against them. The government has failed, as of then, to invoke Magnitsky sanctions. I believe no action has been taken now. Can you confirm that no action has been taken and perhaps speak to that failure?
A few days ago, there was a list of organizations or individuals in Iran that were sanctioned by Canadian government. I'm shocked that I don't see Ali Khamenei on the list. I'm shocked that I don't see Minister of Global Affairs Javad Zarif on the list. I'm shocked that I don't see Ebrahim Raisi on the list, the current president of Iran. So we also had a list of the Civil Aviation Organization in Iran, those people that they tried to cover up this crime, and the military court in Iran, the prosecutor, the military prosecutor of Tehran, the one who said to the families, we killed them, good thing we did. So these people, they should have been on the sanction list, and we know that Minister of Global Affairs, she welcomed the new names, but the names were already there. We gave the names more than a year ago, and summer of 2021. So we hope that we see Ali Khamenei, Javad Zarif, Ibrahim Raisi, and the rest of the these individuals on the list very soon.
Thank you for that. And back in June, you spoke about the fact that the IRGC is active in Canada. I would submit Canada could be characterized as a safe haven for the IRGC. Would you concur with that?
There are reports that they do money laundering in this country, and if you notice on the news on January this year, there was a picture of one of the former IRGC commanders, Mortaza Talai, that he was a former head of police department in Tehran at the time of killing Zahra Kazemi, the same individual who organized this so-called morality police in Iran. He was in GTA, running on a treadmill. And that was another shocking news for Iranians. We know that this is a tip of the iceberg, I think. This is the one that we saw on the news and on the social media. And I'm sure that there are lots of these individuals related to IRGC. And we get a lot of messages from Iranian people right now, that these people should be expelled from this country, their family members, not only them, their family, because they are very smart in money laundering. Probably their assets or their properties is not under their name, but their family members are involved in this kind of crimes as well.
And finally, if you could just speak to the harassment that the victims' families are experiencing here in Canada by the IRGC.
Again, 2 reports has been published so far by CSAS, and it's said that the families of PS752, they have been harassed and intimidated in the soil of Canada. And I can't add anything to that, but we have been threatened, we have been intimidated, and this is ongoing.
Thank you, Mr. Cooper. Next to Mr. Assassi, and welcome to the committee, Mr. Assassi, for 6 minutes.
Thank you, Mr. Chair. It's a great honor to be back at the Justice Committee, albeit just for an hour. Now, Mr. Esmailian, welcome back to Ottawa. We have seen you do an incredible job advocating on behalf of the families, and it has now been well over 2.5 years. As you know, earlier this week, our government did announce that they were sanctioning high-ranking officials. Some of those names were names that you and the families had submitted for consideration. The question I wanted to ask you is, as you know, the minister has indicated that this is only a first step. So are there any Iranian officials on Canadian soil which are of particular interest to you and you would like to see sanctioned?
Yeah, I can mention one name that we have been asking for a long time to be expelled from this country, and that's Farhad Parvarish, Iran's representative in ICAO. He lives in Montreal with his family. This is the man who denied attacking PS752 on the first 3 days. This is the man who insulted our government that they are lying. No attack has been happened. And this is a man who has strong ties with Quds Force. Javad Zarif, there's a tape, there's a recording that Javad Zarif, the former foreign minister of Iran, said that Farhad Parvarish, at the time he was the head of Iran Air, he cooperated with Qasem Soleimani to smuggle weapons to Syria and military personnel. And this person now is in Montreal with his family. So we have asked several times to expel the ambassadors of Iran from European Union countries, and from other countries they have embassy of Islamic Republic of Iran. But the point we can start from is here, from Farhad Parvarish, from Montreal.
Thank you for that. That was very helpful. I will make sure that I do bring it up with department officials. Now, my second question is, as you know, it's been 3 weeks now where we have seen brave Iranians take to the streets in cities across Iran. Now, given that there is discussion about the IRGC, and I know you care deeply about this issue, Would you mind sharing with members of this committee what the IRGC is doing to protesters on the streets in various cities in Iran?
Before I answer that question, Mr. Essasi, I want to bring 5 names of the young, brave women that they were killed by IRGC. Mahsa, Nika, Hadis, Hanane, and Sarina. All of them between 16 to 22. And these are the young, brave women. They go to the streets and they shout for their freedom. They fight back. So we have to show that we stand with them. And when we see the horrible videos coming from Iran, that the IRGC and their operatives and the plainclothes talks that they have, they're attacking these innocent people, unarmed citizens, and they kill them, it's unbelievable that the free world doesn't react the way they should. I mean, it's good to have flag of Iran on the Parliament Hill. It's good to have flag of Iran on the Niagara Falls, but these are just symbolic. We need some concrete actions to show them that we support them. And putting IRGC on the list is a good step to show to Iranians that we are serious about justice and human rights.
Just to reiterate, the Minister has said this is a first step, and that's why your testimony is so valuable. Thank you for that. Now, my last question is, we have all heard reports of how you yourself and other members of the association have been intimidated on Canadian soil. Could you share some anecdotes with members of this committee?
Yes, I remember it was probably 18 months ago, somebody calling me and said, let's talk about the last moments of your wife and your daughter. And I reported that to the police. Most recently, it was probably 4 or 5 months ago, at the time that we had a campaign against a friendly soccer game in Canada. I went to grocery store, and when I came back, I had 2 flat tires. So we have had suspicious cars around our house, and houses, not only me, other family members, they had this experience as well. And we have reported every single incident to the police. And I know our CMP has opened an investigation about the foreign interference, but I have no idea about the details.
Now, you have mentioned how the IRGC should be on that list as well. As you know, there are some legal implications which could ensnare people that are innocent. However, you are saying that the IRGC should still be on that list, and you're saying we should proceed with listing them. Is that correct?
Yeah, I know about, I have heard about the complexities of the case. I've heard from the government that for those people that they have gone through military service in Iran, it makes it a little difficult. As a boy, when you pass 18, you have to go to military service in Iran. Army or IRGC are the main military parts that you go through. And statistically, I think more than 2 million people that they have gone through this with IRGC. I don't know how many of them are in Canada, probably 10,000, 15,000, I assume. So with an exemption letter, or if they exempt them from this, because if you go to military service in Iran, you can't pass first lieutenant. There's a special ranking for you. So we can exempt those people, and we have talked to several lawyers, and this is a simple solution for putting IRGC on the list.
Thank you, Mr. Ismailian.
Thank you, Dr. Ismailian.
Thank you, Mr. Essasi. Next to Monsieur Fortin for 6 minutes.
Thank you, Mr. Chairman. Good afternoon, Mr. Ismailian. I didn't understand quite. You said that there are 176 victims in that attack. How many Canadians were there?
55 Canadian citizens, 30 permanent residents, so totally 138 people, they had ties to Canada.
OK.
And obviously, our sympathies go out to the families of all these victims. How can we help them? I understand that the procedure that you are most interested in, and I share your concern, is getting the IRGC on the terrorist list. Now, besides that, how can Canada help the families of those victims? Have things been done? Should other things be done to help?
The main goal for the families has been finding the truth and justice. So there are two main international bodies to take care of this case, and one is International Court of Justice, the other one is International Criminal Court. Canada didn't show any interest to go to the International Criminal Court. 14th of September this year, the Association of Families submitted their complaint in International Criminal Court independently, and that's why we asked our government to write a supporting letter for us, and also government of Ukraine, Sweden, and the UK, the four affected countries. The other way, that Canada pursues is going to International Civil Aviation Organization and down the road, International Court of Justice. That's what Canada has taken seriously. But so far, after 1,000 days, we have no roadmap, we have no time frame. When we ask for IRGC to be on the list, when we ask sanctions on the perpetrators of this crime, we only ask for the good signals to the families that shows our government is serious about that. So, as I said, the families, they have said no to compensation. They have said no to apologies from Islamic Republic of Iran. And honestly, you can't expect even an apology from Ali Khamenei. He's not that kind of person who apologizes to Canadian people. He has to be on the list of the sanctions. This is one of the first steps.
Thank you. I understand that getting those people and the organization on the terrorist list may help people in their grieving and have these criminals punished for their crimes. But I would like to know whether the families have needs. There are legal procedures that can be carried out against those responsible. For example, the IRGC, the Revolutionary Guards, you're saying that this group needs to be on the list, and we understand that there are leaders. So these are all procedures that would impose penalties on those responsible. But I would like to know as well whether the families need psychological help, financial assistance. For example, somebody who was a bread earner who is now gone. So we've got sanctions, but what have we done to help the families?
I can say at the beginning when this happened, our government financially helped the families of citizens and permanent residents. But the rest of the families that they had ties to Canada were not on the list of the financial help. About the psychological help, I've asked several times for psychological help because a majority of families, they suffer from PTSD and depression. I can give you an example. MH17, the Malaysian airliner that was down 2014. I know that I'm in touch with those families, Air India families and others. And I know that after this happened in Netherlands, 3 universities, they came forward and they started to support the families for 5 years. We never had this kind of services here. Just RCMP said you can be on victim services list. For example, for me, they call me on Father's Day or Christmas Day, and they just share their sympathy with me. But we have kids that were affected. We have mothers and fathers. Some of them are not in Canada, and it's very difficult to help them. That's why our association, we have asked some professional to come and help these families with the language they speak.
If I come back to the sanctions, I've just got 30 seconds, the chairman tells me. I understand that the Minister has refused up to now to put the IGRC on the list because there could be repercussions for innocent people. But are there any other arguments that have been made?
That's the only thing I've heard about the military service people, and that's it. That's it.
Merci, monsieur.
Thank you.
Monsieur Fortin. Next to Mr. Garrison for 6 minutes. Mr. Garrison, you're still on mute.
And how about now, Mr. Chair?
Perfect. Thank you.
Okay. I want to start by thanking Dr. Esmilian for being with the committee today. The scope of the questions we're dealing with is somewhat broader than we normally do in the Justice Committee. But I think your testimony today and your very practical suggestions for what we could do to bring more pressure on the Iranian government are quite useful in this study of victims. But I do want to say at the outset that in addition to the tragedy, or the crime, I guess I should say, not tragedy, the crime of bringing down PS 752, we've got repeated human rights offenses being committed by the Iranian Revolutionary Guard Corps. And those include what seems to have been a ramping up of attacks on women for not adhering to very specific behavioral guidelines that the Corps seems to think are essential for Iranian society. And so we saw the death of Mahsa Amini and the subsequent protests. And the Committee to Protect Journalists estimate at least 35 reporters have been detained since then. Associated Press reports more than 1,900 arrests of protesters. And the Oslo-based Iran Human Rights Group has pointed to killing of at least 154 protesters. And so we see these activities of the Revolutionary Guard also extending to the lesbian, gay, bisexual, and transgender community in Iran. And we had just a week ago a large group of UN human rights experts calling for the staying of the execution of two women, Zara Siddiqui Hamadani and Elham Chobdar, both of whom were accused of promoting homosexuality and sentenced to death. And so it's a broad-ranging spectrum of human rights violations that we can hold the Iranian Revolutionary Guard Corps responsible for. So my question to you, Dr. Esmilian, has there been any attempts of the victims and families to work with other human rights advocates to bring broader pressure on the Iranian government, which is so clearly a state sponsor of terrorism and a major violator of human rights?
What we believe in our association is that we are part of the chain of 43 years of crimes, the crimes against humanity, the war crimes, and we are not an exception. We see ourselves as a part of victims of 43 years. And if you noticed last week, there was a big rally around the world, and our association was involved in that rally. So we helped organizers in every single country in this world to have rally for freedom for Iran. And when we started to organize that, it was only for 8 cities in Canada and the United States and European countries. But then people of Iran or Iranian people, they welcomed that, and it extended to 155 small and big cities around the world. So this was not only for PS 752, this was for all the victims of Iranian regime. And this is what people can do. So with the last 43 years, the Iranian people, they had tried to trust free word to help them. But this time is different. That's why they fight back with the operatives of the regime. Now they act independently, and they're not relied on the politicians of the free world, in my opinion.
I'd like to ask you a question that's perhaps not a fair question to ask of you, but in the light of the failure to take more concrete actions in Canada, what do you think is the cause of this? I mean, there seems to be broad consensus that more needs to be done, yet the government has failed to take some of the very specific actions that you've suggested. Do you have any possible explanation of why the hesitancy?
I've had a lot of meetings with everyone you can imagine in our government that is related to this case, even in the UK, in Sweden, and in Ukraine. So what I hear, because of the process of the legal action against Islamic Republic of Iran, they had to pass the negotiation phase, and on 5th of January 2022, this year, they said that the negotiation with Iran is futile. But in my opinion, I think the core in global affairs, not elected officials, in my opinion, I mean, it's mainly the legal teams or the advisors, they still believe in negotiation with Iran because they don't see Iran or the Iranian regime as a mafia group. If you change your mindset that you're not negotiating with Switzerland or a democratic country, then it will solve the problem. For example, there was a soccer game planned this spring in Canada, and my simple question to them was, do you see North Korea playing hockey in this country? And I heard this answer that that's North Korea. And I said, that's a problem, because you don't see North Korea as Islamic Republic of Iran, as North Korea and Russia. These rogue states, they should be treated equally, and you should not exempt Islamic Republic of Iran from the list.
Thank you, Mr. Garrison, and thank you, Mr. Dr. Ismailison. Next, Mr. Genuis for 5 minutes, and thank you and welcome to the Justice Committee.
Thank you, Mr. Chair, and thank you so much, Dr. Ismailian, for being here, for being the voice of your family and other families, but also for being a voice magnifying the experience and the suffering of people in Iran, in the region, and all over the world who have, as you said, been suffering for decades under the oppression of this regime. And of course, the violence of the regime didn't start with the downing of Flight PS752, and it didn't end with the downing of Flight PS752. As you know, about 2 years before that, we had a motion adopted in Parliament to immediately list the IRGC as a terrorist organization. The evidence was well sufficient at that time, prior to some of the more recent events, and in fact, the government voted for it and then failed to implement it. So the first question I want to ask, kind of building off this discussion of listing the IRGC as a terrorist organization, is, do you know what the government's position is on this? Because I don't, and we've been trying to ask the government. You voted for this motion, no action was taken. There's these messages pushed out about excuses. I hope that you have regular access to ministers. I hope that you're able to ask these questions and hear back. Is the government planning to list the IRGC, planning not to list the IRGC, thinking about listing the IRGC? It's been 4 years since the motion and 1,000 days since the downing of the flight. Do you know what the government of Canada's position is on this?
As I said, it's a puzzle for me, and my answer is no. I don't know. And what I said is that every government is responsible for acting against Islamic regime. If we had done enough when Zahra Kazemi got killed, Dr. Syed Emami would be alive today. And if we had done enough when Dr. Syed Emami got killed, PS752 wouldn't be shot. So, I mean, when they don't see a resolute, firm reaction from our government, I think Islamic Republic of Iran will continue to commit crimes.
Mm-hmm. Thank you very much. And it is frustrating and dishonest when you have a political party trying to push sort of a great fog in terms of a position on a critical issue. If they're not going to list the IRGC, they should explain why. I think they should list them, but they should own up to their position. You presented some names that you'd like to see on a sanctions list. I want to mention that Bill C-281, which is a private member's bill from my colleague Philip Lawrence, will be debated tomorrow, seeks to amend the Magnitsky Act to create a provision whereby a parliamentary committee could nominate someone for sanctions. And that would allow, for instance, the Foreign Affairs Committee to nominate some of the individuals off your list, all of them perhaps, to the government, and then it would require the government to provide a response to that nomination. Because we're talking about listing the IRGC, but it's also notable that that nobody in Iran, nobody connected with the Iranian regime was ever added to the Magnitsky Act, and it may be that will change in the coming days. We don't know. We have the first step taken after so much inaction, apparently, but. Are there changes you would like to see to Canada's sanctions regime to strengthen it and to give parliamentarians more of a voice in being able to push forward names onto the list?
Of course, we encourage everyone to add names to this list, and it's a long list. It's not just IRGC commanders. As I said, there are a lot of people in Iran that they commit murders and they're part of this repression in Iran. All of those names should be on the list because this is a big concern for Iranian people that Canada has become a safe haven for the criminals of Islamic Republic of Iran. When we see the president's, the deputy president in Iran, her son lives in Vancouver right now. And at the time that my wife and my daughter and some of the victims are buried in this country, and they're living lavish lives. So this is not acceptable for Iranian people. This is not acceptable for Iranian Canadian community. And I'm sure this is not acceptable for Canadians.
Yeah. I have 30 seconds left, so if you don't have time to answer this question verbally, maybe you can send a follow-up to the committee. I hear from so many different diaspora communities in Canada, perhaps foremost among them the Iranian community, this concern about foreign state-backed intimidation and violence, and I think many Canadians are deeply unaware of how big a problem this is, how threats to family members, threats to individuals here are used to silence people who want to speak out against violence happening in their country of origin. Could you make some suggestions about how to support those victims of crime?
I think we not let two operatives of Islamic Republic of Iran come to this country. I think that's the first step. It's not only this country; they're everywhere. They are in media. They're in, we see that there have been some institutions in this country that have been sponsored by a government, and we can see that there are ties with the Islamic Republic of Iran with those institutions.
Thank you, Mr. Genius. Next, we have Madam Diab for 5 minutes. Ms. Diab.
Yes, thank you very much, Mr. Chair. Dr. Ismailian, thank you for being here today, and thank you for being the voice of the families of Flight PS 752 victims. We are studying victim rights, and normally it's not as intense as it was this afternoon. I just want to tell you. I still remember the shock and pain that we felt in my community in Halifax in January when the news reached us. There was a community memorial that was held by Al Rasul Islamic Society in Bedford in my area, but also I joined on behalf of the government of Nova Scotia at the time with friends and families of victims alongside nearly 1,000 people at a community vigil at Dalhousie University that was partnered by the Iranian Student Society in partnership with the Iranian Cultural Society of Nova Scotia. So a number of the victims had ties to Nova Scotia. And I want to read their names because I think it's important that we remember these victims. Dalhousie engineering student Masuma, known as Masi Gavi. Masuma's younger sister, Manid. We had a local dentist, Sharia Fagihi, whose children came to the memorial and spoke. St. Mary's University students Fatima Mahmoudi and Mariam Malik. A former Halifax resident, Shafuki Shupanajid, and her daughters, Sarah and Saba Sadat. So we remember them, and at the time, the universities held scholarships in their honor for the students. and the family of the dentist. It was hard to describe the scale of the loss at the time, and quite frankly, it still is. On Saturday, I marched with the Iranian community and others in Halifax to protest and be the voice of the women and the girls that are being killed in Iran, but also of their families and everybody that's grieving. So can you just speak a little bit about your wife and daughter?
Thank you very much. It was Masuma and her little sister Mahdiya. I just wanted to say her name because I know that for her mom it's very important to hear their names. My wife, she was 42, dentist. We married when we were in university 22 years ago. And my daughter was 9 and 7 months and 16 days when this happened. So very happy family here in Canada. We moved up here 2010, passed all the exams, and me and my wife, we grew up together, and we were the best friends. So I think it's our everyday job to do advocacy for them. Not only me, all the family members. I'm not alone. I'm here on behalf of the association, but we have a big team supporting me. And now I'm sure that they're listening to this testimony and they want to see some actions for truth and justice. That's the most important thing for the families.
Thank you, Doctor. What would you say to the countries around the world who were not directly touched by this particular tragedy and who are reluctant, and don't want to do anything? I don't know all the intricacies. I'm a newer member of Parliament. It's been a year, but it's not something I've studied here. But I do understand, there are things that need to be done outside of Canada.
We haven't seen much from the politicians in the free world. I think one of the first steps is to cut ties with the Islamic Republic of Iran as a punishment. What we hear from the government here too, when we say put sanctions on these individuals, they say sanctions are for changing behavior, not for punishment. But this mindset is wrong. Sometimes sanctions are for punishment, and cutting ties with the Islamic Republic of Iran is for punishment. If you show them that you're serious, then they don't act like that to Iranian people. When you close your eyes and sit on negotiation table with the Islamic Republic of Iran and forget about PS 752, Bloody November, Grieve movement, all 1988 massacres, all of those crimes. So it shows that you're not serious and you're not supporting Iranian people. People are important for us. People should understand that the ones that are running that country, it's not a normal government. It's a mafia gang.
Thank you. Thank you, Ms. Diab. Monsieur Fortin for 2.5 minutes.
Merci, Monsieur.
Thank you, Mr. Chairman. Ms. Dr. Ismailian, I have the impression that we have looked at the main aspects of your demands, and I think all of us around the table share the pain that you have in having lost your wife and your daughter, and I understand what you are calling for. You want the Iranian Revolutionary Guard Corps to be added to the terrorist list. I do understand the reluctance of the minister to have innocent people perhaps bear repercussions of that decisions. But I do understand that you have consulted lawyers who are expert in this area, and that it would be possible to add the organization to the list, but still protect those who would have been affected and be innocently affected. So what steps should be taken to make sure that we don't create innocent victims if we add the IRGC to the list?
If the lawyers of Global Affairs are, they want to have a meeting with our lawyers, we welcome that. This is what we have suggested from the beginning, not only because of IRGC, for the roadmap for justice, and there have been like few meetings in the past, but usually they're not open to give any information. So we offer them the solution, and we can help. We can help to provide the list. We can help for the case. But as far as I know, they want to act independently, and the legal representatives of the victims, they have no role of making decisions.
Merci. Mais
Thank you. But how concretely can we do this? How can we protect those innocent victims? Do you have any information on that? What are your lawyers suggesting?
You know that I'm not a lawyer, but probably legal advisor is better to answer that question. But what I know is that everybody who passes military service in Iran has a card, and that card shows that you are not, you have been in IRGC involuntarily. So that shows everybody that you were not part of the organization. You had to pass these 2 years. I think that would be an easy solution for that.
Thank you.
merci, mes condoléances encore.
Thank you, and once again, I offer my condolences.
Thank you, Dr. Ismailian. I want to thank you for your testimony. You've obviously been through a very horrific situation, you and all the families in PS 752. And we thank you for coming and sharing, and hopefully some of the advice you've given us will be taken back and addressed in a timely manner. So that concludes the committee, the testimony of the study. We have a little bit of committee business, so you're dismissed. You're more than welcome to stay there if you want. But very quickly, we just have the budget to pass. I think for this study, I think you guys all have it. You're all okay with it? Okay.
J'aurais besoin d'informations.
I would like some information, Mr. Chairman. I saw that there are some additional expenses. I thought we were talking about 2 witnesses from Vancouver, $2,000. What is actually included in that amount?
Do you want to, Mr. Clerk can answer that probably better than me.
Sorry about that. Désolé. Monsieur Fortin,
Mr. Fortin, we include air travel, so plane tickets, as well as hotel accommodation for one night. That's basically what is included in the supplementary budget. So a hotel for a night? Okay. In the other case, it's somebody from Calgary. That costs a little bit less. Is it because the plane costs less? Yes. So $1,750 instead of $2,000. So $250 is the difference. I've been to Vancouver a number of times. I thought it cost $700 or so, maybe a little more. Maybe I don't have up-to-date prices. I just wanted to get an idea of what was included. Well, we give an average, and we hope that people can come in below that. It was just a detail. Thank you. And thank you, Mr. Chairman. Thank you, Mr. Forman.
If we're all in favor of that, my next, we have one more hour of victims of crime, which will be on the 17th. So when we return back after Thanksgiving, we'll be starting C28 right after that. So I would just ask if you can have all the witnesses in by October 12th, the names of witnesses. That would be Wednesday, am I right? Yeah, Wednesday of next week.
Witnesses for the final hour?
Mr. Clerk, do we have enough witnesses for the final hour?
yes, I'm giving some more. I'm returning to some of the witnesses that have declined because of time. We'll see.
So, yeah, Mr. Nansangari?
So just so that I'm clear, Mr. Chair, so the first hour will be to finish the study.
Correct.
The second hour, would that be for drafting instructions on the study, or would it be witness testimony? Because at some point we need to.
Committee business on C20, maybe on C20, if we have the list, just to verify.
So we wouldn't start the study that day, we would just do committee business after that?
Yes.
Yep. It would be committee business to see C28, and then if the analysts can tell us, so would they be able to have, when they'll be able to have draft report for us?
Yes, so drafting instructions could be given on that date
That was gonna
if
be
the
the
members
first
are
meeting
ready,
back.
although
It's okay.
there'll be an hour of the meeting
On the 17th.
that you might not have in mind, but it's up to the committee members to decide when they would like to give us instructions.
All right, if that's it, I'll suspend, and I think we'll discuss travel on the day sorry?
What's the decision
Oh,
for the
sorry,
second hour?
I missed it all. I thought they gave you a date. So I was talking to the clerk. What's the? Oh, no, okay. We have it on the 17th. We can we can start drafting instructions that afternoon if everyone's okay with that. Thank you.
Thank you, Mr. Chair.